How to avoid misrepresenting yourself to IRCC. Hello everyone, and thank you for joining us in this video. In today's session, we will explore how to avoid unintentional mistakes in completing your forms and avoid misrepresentation in applications submitted to Immigration, Refugees, and Citizenship Canada. Before we start, my name is Reza and I work with the Ingwe immigration team helping applicants move to Canada. Whether it's for yourself, your kids, your business, or all of the above, we make it happen. Are you tired of immigration companies or agents pushing one specific program down your throat without providing options based on your unique profile? Instead of them deciding for you, well, when working with our office, you're in control of your own destiny. And the final decision is up to you, not us. Let me make this clear. I'm not an actual full-time YouTuber, but I work hands-on with our licensed team here in Canada, working on actual applications and communicating with the immigration departments and the overseas embassies on a daily basis on behalf of our clients. These videos are made for the purpose of sharing our hands-on immigration knowledge with our worldwide audience. And if you're thinking about immigrating to Canada, we're here to help. Get a free email assessment with us by filling out the form down below this video, or reach out to us directly if you're an active immigration practitioner already working in this field. Misrepresentation can have serious consequences, including the rejection of your application or even a ban on entering Canada. By the end of today's video, you should have a comprehensive understanding of the steps and precautions necessary to avoid misrepresenting yourself in your application to IRCC. Remember, accuracy and transparency are crucial for a successful and trouble-free business immigration. First of all, let's understand what misrepresentation is in the context of immigration or visa applications. When we discuss misrepresentation, we are referring to the provision of false or misleading information during the submission of an application to IRCC. This includes concealing relevant facts, presenting false documents, or making untrue statements to gain approval for a visa. Most of the time, applicants end up misrepresenting themselves because they could not understand the question being asked. On occasions, IRCC uses very specific legal jargon, making some statements and questions easily misleading. However, even when these errors are not made intentionally, they can have potential short and long-term consequences for future immigration processes. As immigration consultants, we continually hope for IRCC to simplify these procedures, making them more accessible for everyone. However, until such changes are made, let's figure out a way to understand and answer these tricky and confusing questions correctly. The first question we have seen many applicants struggle to understand and often answer incorrectly is, have you or any of your family members listed in this application ever been convicted of or are currently charged with, on trial for, or party to a crime or offense, or subject of any criminal proceedings in any other country or territory? While applicants understand the first part of the question is about being convicted or not, many applicants fail to see the difference between being charged and being on trial. Consequently, they erroneously believe that if they are innocent and not yet on trial, they should respond no. The crucial thing here to understand is that IRCC is not asking if you are innocent or not. They are asking if there is a pending charge against you. Even if you are innocent and you are not facing a trial in a court of law currently, if there is a pending investigation against you where police have charged you with an offense, the answer to this question should be yes. For instance, in some countries, drunk driving may result in only a fine, yet it is imperative to declare this as a conviction in your application. The crucial aspect to grasp regarding this question is that even if you haven't been formally charged with an offense in your country, you could still be deemed to have been charged with a criminal offense if you have a DUI on your record. We also see applicants providing wrong information when asked if they or any of their family members included in the application have been refused admission to or ordered to leave Canada or any other country or territory. To understand how to answer this question, it's important to know the meaning of both of these terms. That is, refused admission to and ordered to leave. Being refused admission to any country refers to a denial of entry before actually being allowed into the country, while an order to leave any country refers to a directive to leave after having already entered. Refused applications can happen for many reasons, and they do not automatically predispose another application to rejection. However, if not properly disclosed, an officer can and will refuse your current application solely based on the fact that a previous refusal was not mentioned. Orders to leave, on the other hand, could be indicative of more serious issues, such as violations of a country's laws or overstaying a visa. These instances are treated with greater scrutiny and can significantly impact the assessment of your character and compliance with immigration laws. With this being said, it is also imperative to disclose such events accurately, as they provide immigration officers with essential context to evaluate your application thoroughly. For example, in some countries like New Zealand, being out of status or unlawful for more than 42 days automatically categorizes you as having been ordered to leave, even if you exit the country voluntarily. In conclusion, if you have traveled outside of your country of citizenship or current country of residence, you should recheck all your entry and exit dates to ensure nothing of this sort is applicable to you. We would always suggest being extremely cautious in these scenarios and check the immigration regulations of the countries you have visited and overstayed in the past. Another challenging question for some applicants arises when they are asked if they or any of their family members included in this application have been detained, incarcerated, or put in jail. It's understandable that individuals who were detained and then released, particularly if deemed innocent, might lean towards answering no, thinking their release negates the incident. However, it's imperative to choose yes and provide a comprehensive explanation of the circumstances in your application. The instinct to opt for no based on the outcome of being released or found innocent overlooks the importance of full disclosure. Transparency about any encounter with law enforcement, even those that did not result in charges or were followed by a not guilty sentence, is essential. This approach not only ensures compliance with the application's requirements, but also avoids potential misinterpretations that could adversely affect your application. While filling out the application forms, clients usually do not bother about their travel history and think that it won't matter much. That's a very slippery slope. Let me tell you about an investor who wanted to come to Canada as a permanent resident, but was refused due to misrepresenting himself. During his immigration application process, Mr. Hake, a 33-year-old citizen of Bangladesh seeking permanent residence under the investor class, encountered inadmissibility charges for omitting and misrepresenting crucial information about his previous studies, residency, and work history. The decision, rendered by the Immigration Program Manager in Singapore on May 28, 2010, led to a judicial review. Hake's application, submitted in March 2010, failed to disclose his past residence and studies in the United States for over a year. Moreover, he omitted or misrepresented details regarding his places of residence, education, and employment history. In response to queries from the immigration section of the High Commission of Canada in Singapore, Hake's consultant attributed the omissions to the assumption that a short stay in the United States did not require declaration. However, Hake contradicted this explanation in a phone conversation with a visa officer on May 26, 2010, asserting that he had disclosed all information to his consultant, who had made the error. The subsequent inadmissibility finding, under paragraph 41A of the Immigration and Refugee Protection Act, focused on Hake's failure to disclose and his misrepresentation of relevant information in his application. The court assessed the reasonableness of the visa officer's decision. The analysis of the case revealed undisputed facts, acknowledging Hake's omission of information about attending school in the United States for 3 semesters, from November 1997 to December 1998. This information came to light during the visa officer's review of the Field Operational Support System, FOSS, which contained details about Hake's past visits to Canada while he was in the United States. Despite arguments from the applicants claiming unintentional misrepresentations and attributing errors to the consultant, the court upheld the inadmissibility finding. Emphasizing the duty of candor for foreign nationals, the court affirmed that Hake's failure to disclose information, such as his year-long study period in the United States, discrepancies in home addresses, and work history, was a material and relevant omission affecting admissibility. The court rejected Hake's contention that he corrected the misrepresentations, highlighting that the discrepancies were only revealed when his previous temporary resident visa applications were compared with the information in his permanent residence application. The judgment reinforced the duty of applicants to provide truthful and complete information, underscoring the potential risks associated with omission or misrepresentation in the immigration process. Hake's attempt to shift blame to his consultant was dismissed by the court, emphasizing his personal accountability as the applicant who signed the application. Ultimately, the application was dismissed. In conclusion, understanding and adhering to these key principles can significantly enhance the likelihood of a successful application. This is particularly critical for business immigration applications, which are inherently complex and involve significant financial investments. Minor oversights, such as neglecting to mention a past visitor visa denial, can jeopardize the entire application process. Remember, misrepresentation is not only a legal concern, but can have long-term consequences for your immigration goals. By avoiding common mistakes, seeking professional guidance, staying informed about policy changes, double-checking information before submission, and addressing concerns with transparency, you are empowering yourself to present an accurate and credible case to IRCC. Always remember that claiming ignorance of the law or misunderstanding legal terminology is generally not accepted as a valid defense. Being diligent is the bedrock of a successful application. If you're thinking about immigrating, whether permanently or temporarily, you're at the right place. I can guarantee you only one point. You will know what to expect, the entire process clearly laid out for you, and all the risks identified, including costs. Our legal agreements are based on payment milestones, which are linked directly to your application progression. We do not take 100% advance payment for your Canadian business immigration applications. And if you're looking for discounts, look no further. I know of a great online website called Amazon that offers great discounts on millions of items every day. But if you're looking for results in your immigration plan, that's our expertise. No surprises, no promotions, just results. We have a $1 million liability insurance which protects you and us from mistakes or fraud, as well as a dedicated client trust account with our Canadian banks. Our team speaks over 9 languages, and we help applicants from 49 different countries during their immigration process. And this list is growing every day. Click the link below this video and get a free email assessment for eligible applicants. And if you're ready to apply and would like a one-on-one consultation with me or one of my immigration team members at Adhering, you can also book a session directly using the consultation link in the description of this video.